All right. Good afternoon, everyone. This is Curt, and welcome to a special edition of Fire Law Vlog. And we have, of course, Brad Pinsky is here with us, and we have a special guest, Kevin Fairlie. So, Kevin, welcome. And if you could, I know it's been a while. We did a podcast a while back, but if you could just sort of reorient folks to you as to where your practice area is.
Sure. I appreciate you having me back. So in a nutshell, people ask me, are you a healthcare attorney, a EMS attorney? I think I'm a healthcare regulatory compliance attorney first and foremost. But when I got out of law school in '99, that's really when healthcare compliance was starting to become a thing. It wasn't even, heck, hospitals and that even the larger organizations didn't even necessarily have compliance programs and compliance officers. So I naturally kind of went in that direction. And then in 2003, probably at least the biggest investigation into ambulance or EMS probably got started in 2000. And then 2003, this was a EMS organization that was jointly owned by the two health systems in the area. They did about 80,000 transports a year, 600 employees. And that organization had been investigated for Medicare fraud. And the prior president, I think was his title, went to federal prison. The hospitals, the not-for-profit entity paid $5 million in fines, and then they needed somebody to come in and help clean it up and operate it in compliance. And so I got a call and I went to work for this EMS organization, and suddenly I was involved in EMS. And so since that time, I've worn a variety of hats: in-house compliance officer, general counsel to ambulance companies. I was stuck as CEO for a few times. But largely doing defending major federal investigations into improper billing as it relates to EMS.
All right. And the reason why we're here is that, and you kind of concerned me when you sent the email that you noticed an uptick in fire departments being investigated by, I'm assuming HHS, that there was an uptick in investigations aimed at fire departments. So maybe you could fill us in on that.
Yeah, so when we spoke, I think we had a couple podcasts, even maybe, Curt, from 2017 is when I really noticed that this got started. And in the OIG, the Office of Inspector General under HHS, they're the ones that really investigate these things. They announced they publish a work plan, and in their work plan, starting in 2017, they said that they have found that there are improper payments being made for emergency medical services, so ALS transports. And so I got involved heavily from 2017 to 2019, defending fire departments where the OIG actually showed up at their door, or investigators from the DOJ. And so US attorneys were involved, and these were major investigations. Well, then 2020 came along and something happened in 2020. And that was COVID. And like everything shut down, it seemed like. Right. And the OIG even, I believe they even kind of stated, hey, here for a time period across the board, we're going to put a halt to investigations because everybody was scrambling, dealing with other things. Well, then in the past year, I would say really in the fall of last year, they kind of slowly announced that they were going to be investigating folks again. And the difference that I have seen now, really definitely this year and kind of into late last year, is instead of investigators showing up at people's doors, they are using this tool a Medicare audit called a Targeted Probe and Educate audit, or a TPE audit. So it sounds nice and friendly, but they being the OIG or Medicare only use these for organizations that they think are doing something wrong or have some sort of improper billing. So now we're seeing this kind of flood of these audits. And the concern for me is that I keep hearing across the board is, I just got back from Pinnacle Conference last week, is I give this presentation and then people come rushing up to me saying, hey, we got one of these audits 3 months ago, but we just, thought it was a random audit. And our billing company's handling it. And is this something serious? And I'm like, yeah, it can be serious. So that's what we're seeing now. And seemingly, gosh, it seems like just about everybody, if you're billing Medicare for ALS or, at that emergency level, it seems like just about everybody's getting one of these audits.
Yeah, and let's give you a little more background if I can. So
Sure.
Kevin, I'm in New York State. My background, I've been practicing law since 95. I have a master's in health administration. So I was always going to work for the hospital or the doctor, but I had a great experience working in the Medicaid fraud unit in Boston. And now back then it was on spreadsheets and everything. So it was very difficult these big, massive, dot matrix printers. It was difficult to kind of discern fraud. But I think in New York State, first of all, ambulance billing was just authorized for fire departments starting July 8th. So it is new. And I've been telling people, you better watch out for fraud. But people think of fraud as, oh, I'm not doing something wrong. And what Curt, what both Kevin and I know well is it's not what you think you did wrong or are doing wrong. It's what your third party administrator, your government program, whatever, what they think you're doing wrong. So how these audits happen a lot is that your third party administrator, a private company hired for Medicare, Medicaid, or whatever, they see that you made an error. And then, and on one of your codes, and you didn't report the error. And then they check to see if there's another one. And if they get two, then all of a sudden red flags go up and they're going to come out and, hello, we're the government, we're here to help. And they're going to run a random sample audit of all or certain types. And what they're going to do, they'll look at, for example, 100 claims. And let's say you went to 10,000 calls or 1,000 calls. They look at a statistically relevant sample, at least one they argue is statistically relevant. And if they look at 100 samples and they find, let's say, 10% of incorrect claims for whatever reason, and Kevin and I will review what some of those common claims are. He hit on one. But if they find, let's say, 10% out of the 100 are invalid, then they will request 10% of all your claims back, plus possibly 3 times damages, plus a lot of other icing on the cake for the government to take your money. So these random sample audits are very scary, and they have been held statistically valid, despite they frankly aren't. And the only way to fight them is to go through every single claim and justify every single claim. At least that's what we do. I'm interested to see how Kevin does. But before we get there, if we could, let's just quickly throw out some of the main fraud schemes. And Kevin, when I forget some, let me know. But we've got upcoding, where you move a basic life support call to an ALS call, or an ALS1 to an ALS2. You move it to a higher ALS. We have medical necessity where there was none, but you made it sound like there was medical necessity. In other words, somebody sprained their ankle, doesn't need to go by ambulance, but all of a sudden, boy, you're having difficulty breathing. You look like you're having some difficulty breathing. Let's write that on the form. All right. So that medical necessity, upcharging the mileage, increasing the mileage of a loaded mile where you have the patient in the back. Kevin, what else are some of the common ones? Those are the ones that kind of always jump in my face.
Yeah, those are the ones. And you're a few things. You're absolutely right. You know, even early in my career, the way these investigations got started was a whistleblower, or, you know, someone had to file a complaint. But it's changed, and it's changed even a lot over the past 5 years with data analytics. And so most of these investigations, there's one very large one where I was defending 10 plus fire departments. That investigation got started because, exactly like you said, they've decided some percentage of a fire department's calls should be emergency and non-emergency. And if you fall outside of what they think is normal, then all of a sudden you could have an investigation start. And so it's changed. And with these TPE audits, they are not just random audits. And that is the key distinction is, you know, for a long time, people have been used to the random audit. But when you get the letter saying that there's a TPE audit going on, that means that they believe you're doing something improper. And the other thing that's changed is the first 15 years of my career, most of my time was spent with for-profit ambulance companies, right? I mean, it makes sense. They're the ones who stand to, if they do all these things, upcode or add additional miles or make up medical necessity when it's not there, someone stands to profit from that. Well, fire departments and ambulance districts in these municipal organizations, there's no one really stands to profit from it. So what it really is I think a misunderstanding ultimately by billing companies, because most people are going to use a billing company, because by protocol, fire departments, they're always going to send out an ALS level unit. You know, everyone's going to be paramedics. And they're responding to a 911 call. So it seems like, hey, you know, common sense.
ALS evaluation.
Right. But, you know, if someone calls 911 and says, I had a tooth extracted and I think it's infected, send somebody ASAP, you know, and you go lights and sirens with your paramedics and you put on a cardiac monitor. Well, by Medicare standards, that's not necessarily something that can be billed at that higher level. But people are, because that's the way they've always done it.
And
well, you two guys are up at a really high level on this, and I feel a little bit out of my element. But let me just, one thing I think fire departments do sometimes is they'll say, well, we just did whatever the billing company asked us to do. Is that a defense, or is like,
no?
What's the potential liability interplay between the billing company and the fire department?
It's funny. I was just going to jump in on Kevin's comment on the exact same thing. Not so much with Medicare, but there are non-delegable duties, right? So billing is a non-delegable duty. You can give it to a billing company, but they are your agent. So any fraud which they engage in is 100% on you, which is why when we flip over in a moment to compliance, talking about compliance programs, I always get asked a question. Well, the billing company has a compliance program. Is that enough? I'm like, no, of course that's not enough. That's not your compliance program. You need to teach your employees and volunteers about all these fraud schemes, et cetera. But the other interesting thing, and maybe, Kevin, you don't see it obviously on much, as Medicare. Medicare requires that billing companies bill on a flat fee, because the federal office of the Inspector General, and at least the New York State Attorney General, have given the opinion that percentage-based billing arrangements with your billing company, and this is a quote, are wrought with fraud. So right now, Medicare and Medicaid, generally, you're not allowed to bill on a percentage, but that doesn't mean that your billing company, right, can't put you into an audit position by the Attorney General, by the Postmaster General. There are other agencies that can cause these audits, saying, well, you're still engaging in fraud. And that will start with a complaint that you maybe overbilled somebody on a private insurance. So this is more of a private insurance area. But certainly you cannot rely on your billing company to protect you. They're not a shield. I would say they're an added level of disaster in some case, because if they're trying to, manipulate the fees to earn more money, you're on the hook for their errors.
Yeah, it's not a defense to say I relied on my billing company. Although when I'm sitting in front of the U.S. attorney, I'm going to say, hey, fire chief, went out and hired this billing company that specializes in EMS billing. They assume it's being done correctly. Now, what the feds will say is, as Brad pointed out, that, hey, Medicare's contract is with you, fire department, and you are the one responsible for ensuring that your third-party vendors, that they operate correctly and in compliance. And I would say the vast majority of, I'm not sure how many billing companies I've actually seen bill at a flat rate. They bill on a percentage basis.
That's a problem. Just doing that is a problem from what you said.
And I mean, there are plenty of good billing companies out there, but they're almost all for profit, right? I mean, so they are the ones who stand to benefit. And, they say to fire department, hey, we've got a compliance program, we've got you covered, but a compliance program is designed in large part to monitor the billing company to ensure that they're doing it correctly. So it is not a defense at all, in my experience, to just blame it on the billing company.
Yeah, in fact, the billing company, I've had the experience where and in fact, I've seen Medicare allege a conspiracy where they said you conspired with the billing company to commit fraud, which is a whole other, right? And I think they do that intentionally so that you're at odds with your billing company and not necessarily on the same page. I haven't seen that for quite a while, but I have seen that. But, Curt, let me say this to the viewers, as Kevin will definitely, I'm sure agree, a mistake. If I make a mistake for 6 months, a year, 2 years, or my billing company makes a mistake by billing a code they shouldn't have billed, or I didn't know I was supposed to round to the 10th, I'm rounding to the whole number, whatever the error is. And then Medicare, Medicaid, the Inspector General, Postmaster General, whoever, FBI comes, right? And they start saying, wow, you've been doing this intentionally wrong for a year. I'm going to argue it's a mistake. The government's going to argue it was intentional. And a jury, in theory, though I've never had one go to a jury, but in theory, a jury is going to be the one deciding mistake versus intent. And I'm going to throw this back to Kevin now, is explain how the compliance program really protects the department to say, look, if we intended to do something, we wouldn't have gone through the whole compliance route. Yeah,
absolutely. Well, compliance programs are essential, in my opinion. Now, one of the difficulties is you say compliance program to a lot of fire departments, even those that are doing EMS, and they don't know what that means. They'll say,
that'd be me.
Well, my billing company
that would be me.
or they'll say we have a compliance program, but when you get into it, that means they're doing some quality assurance type stuff. But in 2001, the OIG published their compliance program guidance for ambulance. So it's been out there for 20 plus years. Now, this is why, from my experience, why a compliance program is so important to have in place is because what they will use is the False Claims Act to investigate and prosecute you. And the False Claims Act it states that you have to have knowledge about the falsity of the claim. So, if you're submitting a Medicare claim and it's false, but then they define knowledge as intent. So like you actually know it's wrong, or reckless disregard, or deliberate ignorance of the truth. It's those last two that get you, especially the reckless disregard. And I have had cases where we nearly have this thing settled, and the U.S. attorney saying, okay, I agree, I don't want to fool with this. Fire chiefs didn't know they were doing anything wrong. But then the OIG in Washington, D.C. says, hey, wait a minute. The False Claims Act doesn't require actual intent. If these fire chiefs have done nothing to monitor their billing company, they have no compliance program in place, they have no safeguards, that's reckless disregard, and you're still violating the False Claims Act.
Wow.
Yeah,
That's the real kicker.
That's scary.
Yeah, and I got to tell you, people have no idea. And if you're in what I'll call an under audited area, in other words, an area where the OIG wants to make an example of you, and I think they do. I think the OIG wants to make sure they have enough of these on their books where they can release the report and say, look, here's what happened. Kevin, I had the benefit of being able to audit for 5 years because it was part of a settlement, a Massachusetts ambulance company, and we would audit about 100 of their claims a week. Very busy company, a week,
Wow.
$25 million, settlement, so to speak.
Mm-hmm.
But the cost to them, I mean, they were paying me numerous $100s an hour for me as an attorney to sit, right? And I can't express enough to the departments the penalties involved, right? It's not just you're paying the money back. It's not just you're paying 3 times the money back. It's not just that you are paying 3 times the money back plus whatever percentage they believe are incorrect, right? Which may be much higher, but jail time is possible. I haven't really seen, I don't know if you've seen anyone actually go to jail over this right. But
only in the
that's still a
for-profit
threat
sector.
though. Even if you haven't seen anybody, it's still a threat. And
Always.
It's one of those things where a chief may not, realize he did something wrong, but all of a sudden now the potential is there. And that's enough to keep you up at night.
yeah.
Well, and the other thing is, I mean, it gets costly, very costly, but the bad press alone, I tell people these investigations can be going on all around you and you have no idea. One of, the first things that I do when I get involved is say, hey, how do we keep this as quiet as possible? Right? Because so many times you end up settling and Medicare is wrong a lot of the time, especially when it comes to EMS. So you end up settling and it's not a major settlement, but if the community at large is aware that there's a subpoena and some investigation, well, it doesn't matter the outcome.
Yeah.
Right.
And that can affect the chief in the chief's next employment or continued employment, that kind of thing. I want to throw this out to both of you because I've seen this several times. It's not just recently, I'd say over the last 10 to 15 years, but fire chiefs being called to whether it's a city council meeting, fire district board meeting, town council, whatever it may be, and questioned on why the recovery rate on EMS is so low, to the point where there's political pressure put on the chief to increase revenues that way. And, and also I've seen billing companies replaced because of the low recovery rate. And, when you couple that kind of political pressure that's being put on a fire department leadership with this reality, it's a recipe for a disaster.
I agree. And again, that's where a good compliance program is helpful, because one of the things you're going to do is if you have a governing body, if you're a fire protection district and you have a board, or even if there's a city council, those individuals have some responsibility to make sure that the billing is being done in compliance. So there is training for governing board, because look, when these investigations really get going, they're going to go as far up the food chain as they can, right? So I have been involved in these investigations where board members get called down to the U.S. Attorney's office and brought in one by one. And, they say, so tell me about your compliance program. Tell me, what have you done as a board to make sure that these Medicare and Medicaid
We just put pressure. All we did was put pressure on the chief to increase the rates. We didn't tell him to commit fraud.
Right. I mean, what they've done is the exact opposite. So yeah, they're putting themselves at risk as a board or a city council, if they're doing that, in my opinion.
Oh, they're doing it. Oh, trust me, they're doing it.
Yeah.
And people don't realize, that Medicare, their Medicare requirement, and again, we're focusing on Medicare because these are the most active audits. They're not the only audits, right? Medicaid at state level, there's other audits, but Medicare clearly the worst. But Medicare, you have to bill in the name of the owner of whoever's authorized to provide service. So if it's a town fire department ambulance or a city fire department ambulance, it is the governing board, not the fire chief. The fire chief, frankly, is the one who's going to, if he or she is smart, turn around and hang his employer, which they don't want to. But if it's a choice of them or me in jail, I'm going for them.
People get thrown under the bus really quick in these things.
Yeah. And the good news only for the fire chief is the town board can't say, well, we turned a blind eye. We told our fire chief to do it. We don't look at it. We don't know anything about it. And Medicare doesn't care. Right. As Kevin's saying, Medicare doesn't care. Whoever owns that ambulance service, they're on the hook. And I will tell you, so there's been a lot of, I've been on a lot of webinars, and I have a video series we've put out for New York State fire departments looking at billing. And I talk about fraud and compliance. And I say, before you think all the, the goose that laid the golden eggs just come to New York State, I said, you better understand the pitfalls. If you think you're going to bill it and forget it, you're nuts. I said, there's obligations. And one of the things we're doing a lot of for very little money, I don't know, Kevin, whether your firm does this, but we audit 10% of every bill of our clients, for like $2,000 a year. I mean, it's a joke, but, we'll audit them because it's better money for them to spend that than to spend 10 seconds of time looking at a response from Medicare or a request from Medicare to, hey, we want to see your files. You better be auditing. And I tell people, if you've got a billing company, even though compliance lawyers don't always like this, you'll probably see Kevin shrug in a minute, but I want to do post-submission audits, right? Where the bill has been already submitted. To me, that's the only way where you're going to catch the billing company, who's got their hands in the cookie jar. People don't like the post-submission audits because then we got to turn ourselves into Medicare and say, hey, we incorrectly billed this. And we've done an audit going back a year. We found all the other bills that we did incorrectly. But in truth, isn't that the right thing? But that's all part of a compliance program. And people really better start thinking of auditing, especially if you're billing company percentage-based bills. If you're not auditing your billing company, they're the ones you have to worry about, not you. So going back to the beginning, they're your friend, but they're not.
Right. And I agree 100%, Brad. And so I have the law firm and then the company EMS Compliance, which we provide the compliance program structure for fire and EMS departments. What we don't do intentionally is these third-party audits that you're describing. But one of the 7 elements of a compliance program is that you audit and you monitor. So we have policies and we tell the customers, look, you need to hire a third party like Brad, and unfortunately, there's only a handful of people out there that really have the knowledge to do this, to take a random sample, just like Medicare would, exactly as you're describing, claims maybe that have been paid in the past year, the past 2 years, and do an audit of those claims, just like Medicare would, which is what you're describing that you do, Brad. So we would work, EMS Compliance would work with someone like you to have those audits done, but that's probably the most important thing a compliance program can do.
What's the skill set? Because it's not something I do. It's not something I want to do, but I am curious about the skill set of the person that is going to do that. Like, who should they, besides the two of you, your firms, but outside of those, like what would be the skill set that the person would need to have to do that audit?
Well, Kevin, I don't know if you want to answer this or.
Well, it's someone who understands all of the Medicare's, there's a Medicare policy manual, and it tells you exactly how all of these, how everything should be billed. And
coded. Coded is the other part of that word.
Well, I guess, would it have to be an attorney, or could it be?
It usually wouldn't be an attorney. I've trained people to do it. So what I've done is we've created checklists, right? Of every bill, we're going to look at 8 or 9 different things. And you do have to have, I started doing it because I have 22 years on the ambulance and worked in Medicaid fraud for a while. So I think my background leads to being able to do it. But I frankly think any EMT or paramedic could do it if they have a checklist of what to look for. The harder part sometimes is you have to look at what was coded, and you have to understand the billing code. We have a whole coding system for Medicare. Kevin referred to Chapter 10 of the of the ambulance billing rules. You do have to understand coding, and there are coding certifications. In fact, anyone who's looking for a job to work from home, you should be a medical coder. It's not great money, but it's not bad money. But coding is complicated. And so what we're normally doing is telling people to look up the codes, but we look for the 7, 8, 9 top fraud and error issues. And once you get past those, and one of those, which isn't really fraud, is the proper documentation of medical necessity, which is another thing we should talk about, because frankly, people have to learn how to rewrite reports. Now if you don't bill, you're writing reports just for the doctor, right? Or just for whatever you think your PCR is worth. But when you're billing, your PCR, your report has to establish medical necessity, and that transportation to the destination you chose was a medical necessity, and there was no other safer or as safe, appropriate, like a taxi or an ambulette way to get there. So I think EMTs and paramedics could do it with a lawyer in consultation. And I hire EMTs and paramedics. It's just, there's not a lot of money in the auditing, because people don't want to pay out a lot. It's, in our view, it's just a service we offer to people because we'd rather not see them in that problem, right? We want to create a defense for them. Now, what we've done is good for Kevin. So what we do is we can't be the attorney, unfortunately, representing our client, right? Having been the auditor, the compliance auditor, we're costing ourselves a client, but we would go to a Kevin and say, okay, you defend it. We're the attorneys saying, hey, we've audited this at a level we think is appropriate, but you bring in a person like Kevin and say, now you and us will work together to defend this claim, but us on the factuals, right? That we've done the audits and the reviews.
So what you're saying is you can't have your attorney do it, or if you have your attorney do it, you're going to need a different attorney to actually defend you.
Yeah, we can't be the witness and the attorney, right? So we're saying right up front to our clients, if Medicare ever comes in, we'll be your best friend, but we won't be your attorney for that portion.
Gotcha.
Yeah.
And Kevin, who do you have like nurses, or who do you have doing your audits?
So again, we don't do, although I could do the audit. It's just something I've elected not to do. And then on the EMS compliance LLC side, where that company provides the compliance programs, there are a handful of people, of organizations that I just know, I've worked with for 20 years, that have that knowledge, where I trust that if they're doing an audit, that they know what they're doing. A person like Brad. So there are countless organizations out there that do healthcare billing audits, but I think it's very important to find someone who understands EMS, because a lot of the billing actually then ties back into operations. Not to get too granular, but what Medicare is really looking at is this BLS versus ALS. And a lot of that has to do with, well, what were your dispatch protocols, and your medical director, and then your operational protocols. So someone needs to understand how fire and EMS operates, and they also need to understand Medicare's rules for how things get billed.
Yeah, and Kevin, that's a good point, because a lot of departments get hung up on the dispatch, especially if they don't use the EMD codes, right? Where a Charlie and a Charlie Delta Echo obviously is going to probably necessitate ALS, alpha betas don't. But where a lot of departments get hung up at the audit level is, wait a minute, you were dispatched, and the nature of the dispatch, which is on your report, the nature of the dispatch doesn't indicate it's a serious emergency. And yet all of a sudden your sprained ankle got turned into a cardiac arrest. How did that happen? Or you're starting an IV and a lock, transporting a stub toe. And so the nature of the dispatch is a big tip off and not difficult to take a quick glance at and compare it with the code. So that's one place that I totally agree with Kevin, that's going to hang them up. And you better explain it in your PCR pretty well.
Right. Documentation training is huge. And usually, occasionally there will be an audit where, hey, everyone's doing the right thing. The billing companies understands the rules, they're billing correctly, but most of the time you're going to find issues. And a lot of times that ends up having to do with the documentation. Are you getting the right signatures? Are you appropriately describing medical necessity? Well, then that takes training of the crews, so then you got to figure out how to get all your crews in there and do some training. But so the audit and the documentation training usually kind of go hand in hand.
Right. And we find a lot of problems come with the less frequent issues, such as hospital destination. Medicare only pays to the closest appropriate facility, and questions come up all the time. Well, wait a minute, the closest facility isn't a stroke center, and the county's designated a stroke center, which is 20 more miles away, giving us another $15, $18 a loaded mile. And so we went there, and these because mileage is big money. Mileage is a good source of money, but you got to document that you went to the closest appropriate hospital. And I think places get really hung up on that, not documenting why they went to a different hospital, or just putting upon demand. But upon demand isn't a Medicare excuse. And the billers then, not familiar with the area, especially when you get a out-of-state biller who just doesn't know the closest hospitals, then bills consistently because, well, you went to a hospital 5 miles farther. Well, those 5 miles over 1,000 trips is a lot of money. For every $1,000, and look at this, every 1,000 miles, which is not a lot of trips, for every 1,000 miles, that could be $18,000 of overpayments. Multiplied by 3, multiplied by how many years back. And Kevin, why don't you talk about how far back they can go?
Yeah, 7 years.
Oh boy.
Yeah.
It starts adding up.
You're going to say 2 or 3.
You can get astronomical numbers that just no one would ever be able to pay back. But that's what they do is, they come to you and say, okay, you owe us $200 million. And
we'll take 45.
That's a pretty good negotiating position, right?
Yeah.
So yeah, the numbers add up quickly.
Well, we've been going now for about 40 minutes, so kind of like to wrap it up. We know when we have longer vlogs, folks tend not to bother even listening. So, but
okay.
Kevin, do you have anything you wanna wrap up with?
I would say if keep an eye out for TPE audits. Even ask your billing company if you haven't seen anything. Say, hey, have we received a TPE audit? And understand that if you've got one of those audits,
they're not random.
It's not random. You should take it seriously. Don't rely solely on your billing company. Make sure you're involved in that because, if something bad comes out of that, it's going to land on fire department. So be watching for those TPE audits and get a compliance program in place.
And Brad, I know we'll include the link to your video on the compliance program. So Brad, you have anything to wrap up?
I think Kevin said the right thing right at the end, which is you get a compliance program in place. If you have not enacted a true aggressive compliance program, you are literally playing with fire, because you are giving up the best, easiest defense that takes, you got to appoint a compliance officer, but the training of your employees, an hour a year, and engaging in these audit reviews and things. And listen, if you like Kevin, if you like me, if you like, this is not legal work. Creating a compliance program, I would say, is not the practice of law. So if you like Kevin, he can go to any state, and vice versa. I think you can really go to any state to implement these compliance programs. And the training is so critical. I'm sure Kevin does the training with it. The training is so critical. But again, if you're billing and you're thinking, not my problem, you're nuts. It's going to be your problem in one way or the other. Implement a compliance program, start the audits. And that's the best thing we can tell everyone.
All right. Well, thank you. Thank you very much, Kevin. Thank you for bringing this to my attention, and Brad, certainly for your input. I really appreciate it. And that'll do it for another edition of Fire Law Blog.